One of you guys sent me a letter that you received from TV licensing after you requested to cancel your TV license and request a refund. Now, I don't really agree with what the letter said in response, and in this video I'll explain why. And it's not the first time I've come across this either. I've come across this when trying to lodge complaints with police on behalf of a client, which I'll also explain in this video. But first of all, if you're new to me, I'm Daniel Shensmith, a barrister of England and Wales. I enjoy helping you to understand law on this channel, having done so for several thousand videos now. So I'd really appreciate it if you hit that subscribe button if you find this video useful. So this is the situation. One of you guys, as I said, my viewers, wrote to TV licensing very politely and said, I don't need a TV license anymore. I will tell you in the future if I do need one. I'm cancelling my license. I normally pay by direct debit and I would like a refund, please. And provided the bank details. Now, the bank details provided in the letter would presumably be the same as those used for the direct debit, which TV licensing could have confirmed, which is why I think this is unnecessary hassle. But this is the response from TV licensing. TV licensing came back to say, thank you for contacting us about changing your details on a TV license. We're unable to accept your letter as authority to change the details, as it had not been signed. Please sign this letter and return it in an enclosed reply envelope, and we'll be able to amend our records. I look forward to hearing from you, TV Licensing Customer Services. Now, this is the same old debate that goes around and around about a wet ink signature. Now, many things don't require a wet ink signature. Even warrants don't necessarily require wet ink signatures. And there is a whole host of authorities on this point, to the extent that there's been a law commission review specifically addressing electronic and other signatures in place of a wet ink signature, which I'll come back to in a moment. But I've also had discussions about this with police forces that refuse to accept a letter from me, writing as a lawyer to make a complaint on behalf of a client, coming back to say that it had to be in a wet ink signature of authority from my client, even though we are an authorized and regulated law firm. So obviously I don't agree with that position by the police. And just as a brief interruption, if you do enjoy my content here on YouTube, there's a number of links in the description below that you can help to support me in continuing to create this content here for you on YouTube. You can join as a member here on YouTube. You can go to BlackBeltBarrister.com and there's various subscriptions there. And I plan to pack that full of content that can help you in a number of different ways. You can even receive £50 in credit for free yourself by switching your energy supplier, which will also help me. So please do check out those links. And now back to the video. But even the Police Reform Act 2002, which makes the provision for the making of complaints, provides that another person can make a complaint on your behalf if that person has been given and is able to produce written consent to his so acting of the person on whose behalf he acts. It doesn't provide and require a wet ink signature of the client in order to do this, just written consent. Now, if there's any ambiguity as to what written means, we can go to the Interpretation Act of 1978. This is also the interesting bit of law that says that if a piece of law refers to him, it's taken to be genderless, him or her. And writing is defined in this act as including typing, printing, lithography, photography, and other modes of representing or reproducing words in a visible form, and expressions referring to writing are construed accordingly. And so it doesn't matter whether it's signed or not, if it's in writing and it's written consent. For example, by email, typing your name at the bottom, your initials at the bottom. Many people think this is not written authority, but it very much is. And I'll give you an example why. This is taken from the Law Commission, and this addresses specifically signatures and electronic signatures, among others. And it says here, a statement of the law, execution with an electronic signature. This commission review looked at the law surrounding signatures, e-signatures, and the validity and acceptance, etc. So this is the summary with which everybody, including TV licensing with respect, should take notice. An electronic signature is capable in law of being used to execute a document, including a deed, provided that the person signing the document intends to authenticate that document and 2, any formalities relating to the execution of that document are satisfied. Some of the formalities might, for example, be in relation to a deed. But nonetheless, an electronic signature can be valid, even for a deed. Now, just for the avoidance of doubt, the viewer that sent me both copies, letter to and from TV licensing, did put the name at the bottom and without any rebuttal intended for that to authenticate the document on their own behalf. Such formalities, this goes on, may be required under statute or statutory instrument, and again, talking about things that might need to be witnessed and so on that might relate to being a deed. But an electronic signature is admissible in evidence in legal proceedings. It's admissible, for example, to prove or disprove the identity of a signatory and or the signatory's intention to authenticate the document, save where the contrary is provided for in relevant legislation or contractual arrangements, or where case law specific to the document in question leads to a contrary conclusion. The common law adopts a pragmatic approach and does not prescribe any particular form or type of signature. In determining whether the method of signature adopted demonstrates an authenticating intention, the courts adopt an objective approach considering all of the surrounding circumstances. So for the avoidance of doubt, anyone doubting what courts take as a signature and what, with respect to TV licensing, should take as a signature, the courts have, for example, held that the following non-electronic forms amount to valid signatures: signing with an X, signing with initials only, using a stamp of a handwritten signature, printing of a name, such as in the example of the viewer that sent me this letter to TV licensing, signing with a mark even where the party executing the mark can write, and a description of the signatory if sufficiently unambiguous, such as your loving mother or servant to Mr. Sperling, making quite clear who it is that's signing the letter, the correspondence, with the intention of authenticating that document. Skipping forward, the courts have at point 7, for example, held that the following electronic forms amount to valid signatures in the case of a statutory obligation to provide a signature where statute is silent as to whether an electronic signature is acceptable. A name typed at the bottom of an email, clicking an I accept tick box on a website, and the header of a Swift message. Now, all of these taken from various bits of case law that I've referred to before, and each of those where courts have upheld the validity of a signature, whether typed, whether signed with a cross, whether an exchange of emails. An exchange of emails, by the way, has been held to be valid to form a contract, all sorts of things. So my viewer sending TV licensing a letter to say, please cancel my license and please refund me the money, is sufficient simply to type their name at the bottom. It doesn't need to be signed. It certainly doesn't need to have a wet ink signature, such as the one indicated as being required in this response letter, signature and printed name with a date. This is unnecessary. And as I recently pointed out to one particular police force, in my view, an unnecessary frustration and waste of time. However, there is an alternative, so I'll bring that to your attention as well. There is an alternative which is provided for by TV licensing themselves if you want to cancel and request a refund. You can cancel and request a refund by going to this website. You can Google it or look at it on their website and find it here. And you can go through and request a refund. Now, this, I've addressed wording such as this before now, could be misinterpreted. For example, it says at point 2, you understand and confirm that unless covered by a license, you won't be legally able to watch TV on any channel via any TV service, and includes Sky and Virgin and BT, etc. But that's not necessarily true. If you watch on-demand services through Sky and Virgin, I'm not overly familiar with either of those because I don't have either and I don't watch either. But if they provide an on-demand program or film or prepaid film to watch or whatever, then it is not live. You may still consider that TV, but it's not live. It does correctly then address the standard online services, such as streaming services, and clarifies that they need to be live here, such as Amazon Prime Video Now, etc. But only if they are live. That is what a license is required for, not ordinary on demand. And then you go through this process and you fill in the form to request a refund. And I went through inputting just test, all the way through until it asked for bank details. Now, that brings us full circle to the point about the bank details. Now, ordinarily, I might accept the argument that an organization might want a signature to authenticate bank details and so on, particularly in the case in TV licensing's defense here, if the bank details provided were different. If I were asked to advise TV licensing in that situation, not that I am and not that this is legal advice, but if I were, I might say something along the lines of, I would double check that if I were you. I would not be refunding money to a different account without some other sort of authentication and so on. So in that situation, it might be necessary. It might be a reasonable and sensible precautionary step. If, however, which I don't know, but I believe the case is likely to be, if the bank details are exactly the same, then I conclude that this is just an unnecessary frustration and waste of time, and that TV licensing should have just acted on the letter because the name at the bottom typed in is sufficient, in my view, to be a valid signature, as was held in many court cases and summarized by the Law Commission, as I showed you on here. I will link this in the description below. So I hope you found that interesting. And if you find yourself in a similar situation, just try and cancel it online. It's probably far easier and far quicker, and you'll probably receive your refund far quicker. If you found that interesting, please do hit the subscribe button. And as always, thank you for watching.